Explicit consent. The consent required under Article 9 exemption differs from the consent under Article 6 only in that it must be explicit. In other words, any Article 9 consent must still be unambiguous, freely given, specific, and informed, but it must in addition be explicit. The definition of consent requires a statement or clear affirmative action to signify agreement to the proceedings, but clearly the consent under Article 9 must be more than this. Requiring it to be explicit indicates the quality of the consent is more than a statement or clear affirmative action. This would suggest perhaps consent must be given in writing with a handwritten signature, but the Working Party 29, in its opinion on consent under the directive, allows that explicit consent can be given on paper or in electronic form. You can use electronic or digital signatures or by clicking on icons or sending confirmatory emails. The more recent guidelines from the EDPB on consent under GDPR indicates that explicit refers to the way consent is expressed by the data subject. Therefore, the data subject must provide an express statement of consent, and the EDPB indicates how this can be done in the online environment. For example, by filling in an electronic form, sending an email, using an electronic signature, or employing two-stage verification. Due to the greater protections attached to sensitive data, regulations and courts will likely require a strict level of compliance from controllers who wish to rely on the explicit consent of data subjects to use their sensitive data. A controller must therefore be careful to ensure that it meets the requirements for consent in so much that it is unambiguous, specific, informed, and freely given. Additionally, the consent given must be explicit and set forth the purposes of the processing. For instance, it would be prudent for a consent form to specifically refer to the actual data or categories of data that will be processed, which is not strictly required in the notification obligation under Article 13, although it is included in Article 14. Meeting this requirement of explicitness may require that the consent be in writing or be documented in some other permanent record. It is also important to note that there may be circumstances where a member state law stipulates that giving consent is not enough to avoid the prohibition on processing sensitive data. Where this is the case, the controller will need to look for another supporting criteria. Guidelines from DPAs will likely specify what is required to meet the explicit consent standard. Where writing is required, they pose difficulties for collecting sensitive data throughout the internet, depending on whether local law accepts consent expressed in electronic form as evidence of written consent. Different jurisdictions may hold different positions on this according to the DPA guidance and case law. For example, the combined actions of ticking a box plus pressing an accept button is likely to amount to explicit consent on the internet in the UK. Under German law, however, a consent to the processing of sensitive data is valid only if the consent refers to specifically to the sensitive data to be processed, potentially required just in time on sent notices, in addition to a border privacy statement.